Hello, everyone. My name is Jessica Nelson, and I'm an associate historian for the Joseph Smith Papers of the Church History Department, and it is my pleasure to welcome you to this afternoon's session of the Church History Symposium. The theme of our session today is Voting Rights Denied, Polygamy and the Idaho Test Oath. At the start of this session, I will introduce our speakers in the order in which they will present their papers. Hannah Jung is a doctoral candidate at Brandeis University. She studies the intersection of families, law, and religion. Her dissertation examines the ways that polygamous families kept secrets about their families as the federal government and then the church itself tried to end the practice of polygamy. Hannah received several grants to further her research, including from the Mormon Studies Fellowship at the Tanner Humanities Center at the University of Utah.
All right, well, thanks for all coming out, sticking with us to the end of the conference, or close to the end at least. I've appreciated my co-presenters' real deep dive into the Idaho Test Oath. I'm going to do a much more skimming type of action as I move forward. And what I'm interested in talking about, my presentation is called Mere Opinion, Polygamy and the Reach of Law in the United States. And I became really interested in the idea that Congress or any kind of legal power could have control over what they call in Reynolds mere opinion. All right, so in 1879, the landmark Reynolds v. United States case, Chief Justice Waite articulated a framework for how to understand the free exercise of religion clause of the First Amendment of the United States Constitution. In his decision, he created a distinction between religion as, quote, mere opinion and actions which are in violation of social duties of good order. Congress, in other words, did not have power over religious belief, but could legislate over actions done in the name of religion, especially if those actions were harmful to the order of society. The example of Mormon polygamy, therefore, set an important precedent in ruling on important religious freedom-related cases in the past 125 years. Yet a closer look at the Mormon case after Reynolds, broadly speaking, reveals a much more complex legacy than what we have perhaps assumed. The distinction between religious belief and religious practice is not as clear as Waite initially assumed. Furthermore, both lawmakers and the people who administered the law continued to police religious thought in addition to action. Federal and state officials were, after all, not only wary of men who practiced plural marriage, but anyone who believed in the practice as well. A closer look at the ways that Mormons interfaced with federal law, judges, and courts can show scholars how difficult it is to separate religious belief and religious action. So on face value, Justice Waite's differentiation between belief and action seems not only valid, but also necessary. Exempting any religious action would, as Waite tells us, make the professed doctrines of religious belief superior to the law of the land, and in effect permit any citizen to become a law unto himself. Yet in many cases, it was not merely enough to police a religion based on the actions of its adherents, but also American Protestants cared deeply about governing and disciplining those with nonconforming beliefs. Scholars of secularism have taught that religions must demonstrate themselves as consistent with, quote, the basic requirements of modern society, including democratic governance, unquote. They must demonstrate themselves as compassionate, forbearant, as adhering to the senses and awe of the wonder of the universe, organizing charitable impulses, and directing ethical conflict and nourishing the spirit. That's the role of religion. So to many 19th century detractors, the Church of Jesus Christ of Latter-day Saints propelled adherents into a blind faith and barbaric family practice. Justice Field wrote in his 1890 Supreme Court opinion that the spread of the practice of polygamy is, in measure, a return to barbarism. It is contrary to the spirit of Christianity and of civilization which Christianity has produced in the Western world. So returning back to secularism studies, Peter Coviello has written that religions that fail to demonstrate their compatibility with the modern or the secular nation, as Mormonism had in the end of the 19th century, do not appear as religions at all, or at least legitimate religions. Instead, they appear as bad belief. He uses this term, bad belief. Religious beliefs, not merely actions, made certain people dangerous to American society. What follows then is a series of examples of moments where Mormons faced exclusions or penalties based on their belief in polygamy, or more broadly, their membership in the Church of Jesus Christ of Latter-day Saints. Some of these examples come from federal laws, such as the Edmunds Act, and others from state laws, such as the Idaho Test Law, or Test Oath, and as my colleagues have so eloquently talked about today. But in the spirit of what Sarah Berenger-Gordon yesterday called lived law, I'm going to make an attempt at talking about some of that as well. All of this creates a picture of a legal system with a far more complex relationship to religion than what Justice Waite dictated in his Reynolds opinion. There was no guarantee of protection for religious action from the Constitution, but there was an assurance for the protection of religious beliefs. All right. So excluding people on the basis of their beliefs was exactly what Congress had in mind when they passed the Edmunds Act in the spring of 1882. The Reynolds decision 3 years prior had given the green light to the federal government to pass the legislation that would give more teeth to previous ineffective Anti-Bigamy Moral Act of 1862. In order to effectively prosecute polygamists, they knew that they needed to exclude anyone from the jury who was sympathetic to the practice. The Edmunds Act therefore disqualified any juryman who not only is or has been living in the practice of polygamy, bigamy, or unlawful cohabitation with more than one woman, but also for any man who believes it's right for a man to have more than one living and undivorced wife. And yet, I want to be careful here. What the Edmunds Act did was facilitate the exclusion of Mormon jurors. Justice Blatchford confirmed this in the Clawson Supreme Court case challenging this section of the law, that the whole scope of the law is to prescribe what should be the sufficient causes to challenge, the whole scope of the law is to prescribe what shall be sufficient cause to challenge a jury member, basically. So excluding people from jury service based on their beliefs was and is common practice to ensure a more just trial outcome. The Edmunds Act just empowered the district court to filter out people and act within their powers of exclusion. Choosing a jury is normally a mundane exercise, but it became something the Utah newspapers regularly reported on. Though admittedly not front-page material, court reporters still preserve some of this drama. 3 men, quote-unquote, fell before the Dixon sickle because of their belief in a man having more than one living and undivorced wife at this time, remarked one reporter rather dramatically in 1886. The belief of another man disqualified him from the honor and glory connected with the seat in the jury box. In contrast, another man did not believe in plural marriage, and as he was not a Mormon, he was accepted. All right, so the application of this new exclusionary law was something that the Mormon press also lost no time in protesting. The Edmunds Act, wrote one journalist, is a bold reversal of the maxim that a man should be tried by his peers. Mormons also took aim at the idea that federal prosecutors excluded Mormon jurymen in grand juries convened for the purpose of indicting a number of different types of cases, not only crimes related to polygamy. Should Mormons not also have the ability to weigh in on cases unrelated to polygamy in their community? The Edmunds Act was a tool for district courts to sift Mormons out of the jury box, not just for polygamy, but for other ones as well. All right, so now I want to talk about judges and their discretionary power and how belief factored in to their decisions as well. So another form of vulnerability for Mormons in this time period was the process of naturalization. As a result of long-term missionary work all over the world, but especially in Europe, Utah had a large immigrant population. Naturalization laws in the 19th century meant that judges got to decide whether the applicant has, quote, behaved as a man of good moral character, attached to the principles of the Constitution of the United States, and well disposed to the order and happiness of the same, unquote. Utah judges during the 1880s were, however, unconvinced by applications for citizenship among Mormons. The trickiness of presenting one's belief played out in court one day in June 1889 as a number of Mormon men came before Judge Henderson to be naturalized. The first man, Peter Ellis, according to one court reporter at the Deseret Weekly, was, quote, about to be sworn in when one R.D. Winters interposed asking if Mr. Ellis was a Mormon. To this, the reply was affirmative. Do you believe the doctrines of Mormonism to be true? Was the next question. Mr. Ellis replied that he did. This was followed by, do you believe polygamy to be morally wrong? To which Mr. Ellis's reply was, no, sir. And this was the basis of the rejection of his application. The next man, Hugo Peterson, was a bit more prepared. He admitted to believing in polygamy, but he said that it was not right under the law. The judge persisted, asking Peterson if polygamy was, quote, morally wrong independent of any law, unquote. Peterson conceded and said that he did believe that it was morally wrong. The judge was still not satisfied, though. At this moment, Peter's lawyer interjected, saying that his client had answered all the questions regarding his allegiance to this government and has done so satisfactorily. What this man may believe has nothing to do with it, but it is actions and the sincerity of his intentions that has to be ascertained. Peterson was finally admitted as a citizen, but only after he testified that he would vote to convict a polygamous husband of unlawful cohabitation and would not take a second wife, even if his church commanded it. Scholars of Mormon history have long debated the true effect of Wilford Woodruff's 1890 manifesto, calling Latter-day Saints to, quote unquote, obey the law in regards to polygamy. It took over a decade for the Latter-day Saint community to settle on a definition of what the manifesto actually meant. Yet only a few days after it was ratified in the October General Conference, Judge Zane pronounced his approval of this recent statement by Wilford Woodruff. He continued, perhaps a little prematurely, that he understood that, quote, members of the Mormon Church hereafter must regard plural marriage or polygamous marriage as violation of the creeds and the doctrines of their church, unquote. In light of this new change, Zane declared that he would not make the simple fact that an applicant is a member of the Mormon Church a bar to admission as a citizen of the United States. The good news for men seeking naturalization had a downside for polygamous men who had sentence hearings after the manifesto. Days after the manifesto was ratified in General Conference, a man named Michael Clark stood before a judge in the Utah federal courts waiting for his sentence. Clark had pled guilty to the charge of unlawful cohabitation, and furthermore had said that he had divorced his first wife and legally married his second wife. So there's no problem here, right? And certainly before the manifesto, there wouldn't have been a problem. He would have received a pretty light sentence and moved on. Judge Zane, however, was not yet satisfied with Clark's resolution. He asked Clark if he, quote, understood the manifesto recently put forth by the church was against polygamy and that hereafter it would be against the creed of the church to practice polygamy, unquote. Clark agreed that it was his understanding and left the court with only a small fine. 5 years earlier, it would have been sufficient for a man to merely promise to obey the law and receive a lighter sentence. After the manifesto, judges wanted to hear men give an interpretation of the church's most recent statement and say that they no longer believed in polygamy. The men would plead guilty, and then, often prompted by judges, offered that they considered polygamy, or, quote, considered polygamy right to a certain extent, but since the recent action taken by the church, renounced all such beliefs, unquote. So it was no longer sufficient to just have stopped practicing polygamy. Obtaining a lesser sentence meant that you also had to make a pronouncement that you had stopped believing in it as well. And in this moment, I just want to take a moment to recognize Jeff Turner in the audience because he presented earlier this morning about some really interesting stuff related to this topic in immigration law, and specifically the ways in which immigration law and immigrants would also be asked as to their practice, and importantly for my topic, their belief about polygamy. And so, I don't know who that was. So yeah, I just want to recognize that there's also some there's implications here for what's happening in immigration history as well, although I don't really have time to cover that in the moment. So the last thing I want to talk about is the Idaho test oath. The Edmunds Act, passed in 1882, had already barred polygamists from voting, but anti-polygamists in Utah and Idaho felt that they could go even further. Idaho had the Gentile majority that Utah lacked, and after a brief debate, the test oath went into effect in February 1885. The law dictated that no person was entitled to register or vote at any election who is, quote, a member of any order, organization, or association which teaches, advises, counsels, or encourages members, devotees, or any person to commit the crime of bigamy or polygamy. And it goes on for a little bit, but I'll just cut it off there. The Idaho Test Act was aimed not just at polygamists, but also the Mormons who believed in the practice. And I think this is really important, right? And this is a distinction that, as I've looked, I would love to hear from my fellow presenters, because in my kind of review of the Davis Beeson case, I didn't see anything about the fact that Davis was a monogamist. And that seems really important to me because, the opinion shared by the judge, the Chief Justice, was just all about how the evils of polygamy and how that needed to be legislated against. But there was not as much of a recognition that they were taking aim not just at polygamists, but also at believers or members of the church. So I think that is a really interesting and important distinction that gets a little lost, at least in the documents that I've read so far about Davis Beeson. So I'm going to conclude now so that we maybe have a little bit of time for questions. I want to return back to Reynolds and how Chief Justice Waite asserted that Congress was deprived of all legislative power over what he called mere opinion. Yet, as we have seen, opinion matters. Congress also had no qualms, especially in the 19th century, against legislating against racial identities, institutional affiliation. And that's something that I think is really important about the Davis Beeson case, is that it's what they're really taking aim at is an institutional affiliation or a membership, even if they wouldn't frame it as a belief. There's the fact that your identity is as a Mormon in this moment. That's what matters. But we can look at a ton of different moments in 19th century history and early 20th century history and find that actually identities have very few protections. The 1882 Chinese Exclusion Act, later institutional identities such as in 1903 excluding anarchists from entry, and then communists in 1920. All of those, identities it was a more precarious protection. So in conclusion, I still have a way to go with processing and making sense of these historical and legal examples. The presentations of this morning, but also today, or our current panel, convince me, though, that there really is something to be written about the messiness of belief and the way that belief has been policed, both in formal bills, but also on juries, voting registration, sentence hearings, border encounters, naturalization proceedings, and so on. The secular and Protestant impulse in America meant that belief not only mattered, but could be almost as threatening as religious action. Thank you.
All All right, so we have about 10 minutes for questions. These mics here in the aisle should be on, so you should be able to come here and state your question. Thank you.
My question might be for Hannah or someone else. That I was doing my family history and in South Dakota, and I came across naturalization documents for someone, and there's a line in there that says, "Are you a polygamist or practice polygamy or whatever?" Do you know the history or anything about how that ended up in the naturalization documents anywhere in the country? I don't know if you could answer that question.
I would like to call Jeff Turner to the. No, actually, so Jeff Turner is writing his dissertation about this, and so just briefly, we know that the United States really cared about letting polygamists in, and they still ask people today whether they're a polygamist when they're questions about green cards or coming into the United States. And so, yeah, that's so that question is not, it doesn't surprise me. Maybe since it was happening in a naturalization space, it's a little bit different. But yeah, I would recommend going to talk to Jeff Turner if you want more.
All right, so we've reached the end of our time here. I want to thank all of our panelists again. Please join me in applauding their efforts today. And yeah, thank you again for coming.